Okay, the next case we'll take up is the case of D.M.H. versus Joseph PIETILLA as administrator at Halifax.
Yeah, keep going.
Good morning, Your Honors.
Morning. How much time would you like for rebuttal?
I'd like to reserve 5 minutes for rebuttal.
Okay, you may proceed.
Thank you. I'm Catherine Rollison-Radke, Assistant Public Defender, appearing on behalf of the appellant. It is appellant's position, it's kind of a two-part, that Statute 394.467, subparagraph 6, requires a hearing on involuntary inpatient placement to take place within 5 calendar days of the Baker Act petition being filed, unless a continuance is sought.
Can the legislature require that we decide this case within 5 days?
I'm sorry?
Can the legislature require that we decide this case within 5 days?
No, sir, not on appeal, I don't believe.
Now, I think the question was, does the legislature have the authority to say it's 5 calendar days as opposed to 5 working days?
Yes, sir, it does in limited circumstances. The rules of civil procedure do not apply to cases where there is a special statutory proceeding. If you look at Rule 1.010, there are some specific special statutory proceedings alluded to, but also general special statutory proceedings. Basically, it says the form, content, procedure, and time for pleading in all special statutory proceedings are not governed by the rules, unless the rules specifically provide to the contrary. It's actually the second part of my argument. The first part being that the Attorney General opinion, 97.81, supports the position that the statute, the Baker Act, as it applies to inpatient involuntary placement, does not apply to the civil rules of procedure, and the immediately following section 394.468 states that admission and discharge procedures and treatment policies are governed solely by this part, and such procedures and policies shall not be subject.
I'm sorry, you're looking at 1.010?
Yes, sir. Yes, sir. I'm sorry.
And so these rules apply to all actions of a civil nature and all special statutory proceedings in the circuit courts and county courts, except those to which the Florida probate rules, Florida family law rules of procedure, or the small claims rules apply. And you're taking that language and reading it how?
Well, sir, actually, a case of Salvador versus Fennelly, and there's another one as well, have taken that and applied it to other special statutory proceedings. One of which, in my reply brief, I refer to the Rice Act proceedings, which have their own special time limitations, which were somewhat based on the Baker Act proceedings. And those are taken completely out of the civil rules of procedure. In fact, as of July 9th of last year, they now have their own separate rules. The Baker Act has not been dealt with in the same fashion as of yet, and it appears to be a case at first impression, so that we're asking the court basically for some guidance.
Let me ask you this. Before the legislature created this provision for involuntary outpatient treatment, and you just go back to the statute before, which provided for involuntary inpatient treatment.
Yes, sir.
And you have this language within 5 days, and it doesn't say calendar, and it doesn't say working. Is that ambiguous, where arguably either ways, the court can go either way on that?
No, sir, I think you can look at it, and by inference, that they mean 5 calendar days, because they've specifically used the term 5 working days as it applies to outpatient treatment.
Right, but that came later. So I'm saying before that later provision came in, if you were looking at that 5 days, what would that mean? If you never had the new provision on outpatient, involuntary outpatient orders?
Well, of course, the Attorney General opinion, which is the only thing we have directly on point, says that it means 5 calendar days. And it sort of goes back to the difference between outpatient and
But the
inpatient.
Attorney General's opinion
Yes, sir.
didn't even reference the rules of procedure.
Actually, it does, sir. The opinion actually states that as applying 394.468 to interpret 394.467, that the civil rules of procedure do not apply, and that 5 days means 5 calendar days without any expansion by weekends or holidays.
Let me ask you this. What's the remedy if you're right? Is the remedy that the case is dismissed, or is the remedy that your client has a right to be released for those 1 or 2 days before the hearing?
Well, actually, the remedy, sir, would probably be that there would be hearings twice a week instead of once a week.
No, but in this case, if they have a hearing on the 7th calendar day, the 5th working day, is the remedy, when 5 calendar days comes and there's no hearing, is the remedy that the whole case is dismissed, or is the remedy that the person is released until the hearing is held? It's, kind of like...
I don't know that.
Well, in the criminal context, someone's arrested, there's rules that provide that the state has to file an information within a certain number of days. And if they're in jail, incarcerated, they can't post the bond, and the state doesn't file an information within a certain number of days, the remedy isn't that the case is dismissed. The remedy is that the person's released, and if the state wants to pursue the charges, it still has the right to do so. So I'm trying to figure out what your basis is to argue that the remedy here, assuming your statutory construction is correct, that the remedy is that the whole case is dismissed as opposed to that the client is released until that hearing is held.
I think it would have to be that they would be released, because otherwise the Baker Act for involuntary admission essentially would end when the person walks out of the hospital or other receiving facilities such as the crisis stabilization unit.
If we accept your interpretation of the statute, tell me practically how it's supposed to work, for example, on a Sunday. I mean, we're Saturday. How is it supposed to work? Is the court supposed to convene, every certain period of time to cover the 5 days, or in each particular case is the trial judge supposed to hold a hearing on a Saturday or a Sunday, and if so, where, and how is it conducted, and that sort of thing? Practically, how is it supposed to work if we accept your interpretation of the statute?
Well, sir, there's a certain amount of leeway built in that within the first 72 hours under the statute that a person is brought into the hospital or the receiving facility, they have to be examined by 2 psychiatrists. And the very next working court day, the petition must be filed.
So are you saying that it works out so that we don't ever have to worry about the 5 days being on a Saturday or a Sunday? And
No, sir. No, sir. I'm not. In fact, in this case...
But let's assume. I mean, tell me practically how this is supposed to work. Let's assume we say, okay, you're right. So how are the courts supposed to practically handle these situations?
I think as a practical matter, it would work out that you would have to have hearings twice a week.
When twice a week?
Well, let's say
Tell me how it's supposed to work. I assume that we have to use a measure of common sense in interpreting the statute. We can't, interpret it so that it produces an absurd result, right? You agree with that?
Yes, sir.
Okay, so...
On the other hand...
So you're saying that the courts are supposed to set up automatic hearings 2 days every week? How would that work? What 2 days, and how are they supposed to do that practically?
Currently, they are held on Thursday mornings. Let's say somebody is admitted to the hospital on a Wednesday, and the 5th day runs on Well, and assuming that they are duly evaluated within 72 hours, the next court working day, their petition would be filed.
Would you agree with me that it would be very difficult in terms of practicality and being pragmatic about it and using a degree of common sense? Would you say it'd be very difficult for the courts to set up a system so that, that
No, sir, I don't
you don't
agree.
think so?
No, sir. We
So
have, for example, in the state, every single day of the year, we have first appearances.
Well, let's assume we have a Sunday or Saturday.
And we don't have psychiatrists at those first appearances, and then you'd have to have the magistrate, you have to have a court reporter.
Yeah, I mean, explain to me how all that's supposed to work.
Well, there is a psychiatrist, of course, always on duty. They're always on call.
But let's talk about. I mean, we agree that under your interpretation of the statute, that possibly in cases it's going to be a Saturday or a Sunday where the last day occurs, right?
It may be.
Well, let's say it's a Sunday. So. I'm still looking for some explanation. How is this supposed to work? I mean, where are the hearings supposed to be held? How is the court supposed to be convened? Where's the court person? Is the court personnel supposed to be on call 24 hours a day, 7 days a week, 352 days a year, and that sort of thing? How is all this supposed to work?
They are basically for first appearances, sir.
Well, no, I mean, we're not. I mean, we're talking about a hearing within the 5 days. Would it be an evidentiary hearing of some sort?
It is an evidentiary hearing, yes, sir.
And so we're going to have to set up some sort of procedure where let's assume it's a Sunday, where you're going to have to convene a court somewhere. Where would that be? Do you know?
At the hospital.
It would be at the hospital.
Yes, sir.
Okay, and so a judge would have to be on call, regardless of whether it's a Saturday or Sunday. I mean, if it's during the weekday, the courthouse is going to be open, you're going to have a judge available. So you're going to have a judge on call every weekend to cover these situations. How about the court reporter?
Well, we don't need a court reporter. We have...
Well, I mean, we're having an evidentiary hearing. What if they want it transferred?
Well, someone monitors that. It's not...
Yes.
It's not...
Okay, well, you do it electronically then. You're saying, what if they wanted a court reporter? I mean, they would be entitled to that, wouldn't they?
I suppose they would be if they could arrange for the payment.
Okay, so in other words, I'm still, how this is supposed to work on a practical basis. I mean, I'm still...
Okay, on a practical basis, Your Honor, it would have to be done the same way as we do first appearances. And I'm not saying that would not be difficult or expensive. It certainly would be. However, I feel that appellant's reading of the statute is that it's required, that we read it that way. And there is precedent for the court saying that something that is expensive and some people may argue impractical is still required when liberty interests are involved. And that would be Gideon versus Wainwright.
First appearance is, of course, not a final hearing or trial.
Yes, sir.
Yeah, this is the trial. I'm a little worried as far as the public defender's clients that, if you win this case, it might hurt a number of your future clients because of lack of preparation time. I mean, you're going to be going, you might get notice, 10 hours before you have a case. You've got to gather up your witnesses. I see this as having potential harm to more public defender clients than potential benefit. Am I wrong on that?
Well, yes, sir, because by the very nature of Baker Acts, they are immediate. Under the statute, the public defender is appointed automatically at the first opportunity, which is basically when the petition is filed, automatically appointed.
But if you went to two times a week, say you had, Wednesday and Monday.
It would become a full-time
All right,
job.
So if you had a Tuesday petition filed on Tuesday, Monday's too late. So then you're having the hearing the next day.
Yes, sir, that's what happens
You don't
normally.
see that as a problem for the public defender and preparing for a case and ensuring that their clients' due process rights are protected if they have 1 day notice from the time of petition to gather witnesses?
Well, sir, you can always ask for a continuance.
But it's in the discretion of the trial judge, right?
It is.
So are you saying if we set up a system like on a Wednesday and a Monday, that we'd never have to worry about weekend hearings and that sort of thing? I mean, would that
I'm
cover
thinking-
all scenarios? In other words,
Yeah.
if that's the procedure that the court set up, or something like that? I mean, we'd never have to worry about the...
I can't say never. I'm saying it would be less likely because of the time constraints for filing the petition, for the 72 hours to be evaluated by 2 psychiatrists, and the thing that's already in there is that the petition is filed on the next court working day, the public defender is appointed on the next court working day, and
So then if this is one of those cases that falls on a Saturday or Sunday, you just got to get a judge somewhere and get him down to the hospital, and that means that if that's the case, then you're going to have a judge on call to handle those potential cases every weekend.
yes,
And along with court personnel as well.
And the psychiatrist will have to be
Yeah.
available
Yeah.
every weekend.
yeah, well, one of the two who is signed the petition.
And you think that's what the legislature intended, or that's the purpose of
Yes, sir.
the language? You really think that's what they intended?
Let me ask you this. The legislature here adopted a new statute on involuntary outpatient.
Yes, sir.
Do we assume that because they used the term working in the new statute, that they intended possibly to change the old provision that dealt with
no, sir.
inpatient?
No, sir, I don't. And I think that they dealt with it. They're presumed, of course, by law, as I alluded to in the brief, to know the statute in and out as it existed previously to their making a change. And they didn't make changes in both places. And it's not inconsistent for them to do that because an outpatient person is still able to go about their business. They're not being deprived of their liberty. But involuntary inpatient admittees are being deprived of their liberty. And I think that's where the legislature is looking to protect, is the person's liberty interests. Going back to 1971 when Maxine Baker...
Right, but when they did the new statute on the outpatient, they said 5 working days. They didn't go back to the provision that was already in existence on inpatient and say either 5 working days or 5 calendar days. They left it the way it was. So we to draw an inference one way or another because they could have gone back and said 5 calendar days, or they could have gone back and said 5 working days. I mean, why should we draw an inference that they intended to change this other section just because they created a new section on outpatient treatment?
It's just the plain reading of the statute, Your Honor.
But the plain reading doesn't say, it just says 5 days. I mean, if they wanted to make it plain, they could say 5 working days or 5 calendar days. That would be very plain. Would you agree?
It's almost like legalese, when you go to McDonald's, the sign says, the coffee may be hot. It isn't really necessary, is my argument. 5 days means 5 days, and we can look to the dictionary if necessary. There's precedent for that.
Okay. We have 2:20 left, so.
Thank you, Judge.
May it please the court, my name is Harold Hubka. I'm with the law firm of Cobb Cole. I'm here representing the appellee, Joyce Pietilla, the administrator of the Halifax Medical Center Psychiatric Unit. And I think I would first like to point out that there was a reference to a particular rule of procedure and a case citing that I was somewhat blindsided. That was not cited in any of the briefs coming in here. Rule 1.010 was not in any of the briefs, so just point that out to the court. I haven't seen it, I haven't looked at it, I don't know if it's applicable or not, but it wasn't in the briefs. I think that from the comments that the court has made, that the court is aware of the historical process of how in 1971 the Baker Act was first created. It was an inpatient proceeding. The certain substantive rights were created by the legislature, which gave the patient the right to a hearing within 5 days of the petition being filed. There was nothing at that time in the statute that said how the court was to count those 5 days. Naturally, you go back to Rule 1.190A, and that gives a procedure. And in fact, That rule, when you read it, it expressly says that it is applicable to computing the time for statutory time frames that are in the statutes. So for a long time, we had the Baker Act proceeding. There wasn't any real question as to how you calculated the days. Then in 2004, the legislature came forward. They created an outpatient Baker Act proceeding, and in that they inserted the phrase working days when talking about the 5-day period for the placement hearing. So the question and the argument is being made by the appellant that the legislature somehow, in adding the phrase working days to the outpatient proceeding, intended to make a change in a totally separate statute, the inpatient proceeding, by modifying that statute without articulating the modification, but just assuming that we would somehow infer it. And I think when you go back to legislative interpretation, what you do is you try to parse the legislature's intent. And I think if you look at these two statutes, the timing when they were passed, how they came about, that it's just not logical for this court in interpreting these two statutory sections to conclude that in 2004 the legislature intended to rewrite the inpatient procedure by making changes and creating a new outpatient procedure. That's not a logical interpretation. If they had wanted to do that, as the court stated, they would have in fact made that change at the time they were revising Chapter 394. They could have created a new section, modified the old section.
Could the legislature say 5 calendar days?
Could it have said that? Yes, it could have said it, but I think
so should we be concerned about the practicalities? If the legislature had the authority to say 5 calendar days, courts deal with it?
Well, I didn't say they had the power. I said they could have said that.
Right. So I'm just saying, should we be concerned with the practicalities?
Yes, I think you should be concerned with the practicalities.
Okay. Why is
I think
that?
we live in the real world. I think there are issues of timing, getting the psychiatrists there, getting the judges available. You could actually have an adverse impact on the client of the public defender's office. I mean, these Baker Act inpatient proceedings are a little bit different. They're more for the protection not only of the public in general, but also for the protection oftentimes of the inpatient themselves. So having them released without ever having had a hearing when the intake facility had a determination from a psychiatrist that they should be placed in a Baker Act setting, and then having them released without ever having a hearing at all, probably not in their best interest in many opportunities or many times. But let me go back and say that in addition to the practical problems, there's a real separation of powers issue that I focused on in my brief, and I think the court should look at, and that is that it is true that the legislature can create statutory procedure. They can, when they create a substantive right, they can create certain time frames within which those rights are exercised. And in some instances, the courts and the court cases have even allowed the legislature to go so far in that procedure as to put in some methodology for computing days. But the case law is pretty clear that that's tolerated only in those situations where the methodology for computation of days that would affect a trial court as to when they calendar something or when they do something, that is only applicable and can only stand and does not create a constitutional issue in a situation where it doesn't conflict with an already existing rule of civil procedure. And in this case, the Florida Supreme Court has already articulated Rule 1.190A for computing days in just such a situation, where there's a statutory time frame.
I don't know if I understand the separation of powers argument. It seems to me that that rule covers the situation where the statute is unclear. So if you have a statute that doesn't say calendar or working, the rule of procedure says, you know, if it's less than 7 days, you count it this way. If it's more than 7 days, you count it that way. That they're just telling the courts and litigants how to calculate the time when the statute's not clear. But if, for instance, this statute said 5 calendar days, would there be any separation of powers or any conflict with the rule?
Yes, Your Honor. I think probably the best case to address that was the fairly recent Supreme Court case of Massey versus David at 979 Southern 2nd 931. It is cited in my brief, and at 937 of that case, the Supreme Court pulled together this whole situation of statutory procedure and when the legislature can implement it and when they've gone too far. And basically, I think the provisions that are applicable to our case is they say that, moreover, where this court has promulgated rules that relate to practice and procedure, and a statute provides a contrary practice or procedure, the statute is unconstitutional to the extent of the conflict. And then they said, finally, where a statute has some substantive aspects, but the procedural requirements of the statute conflict with or interfere with the procedural mechanisms of the court, those requirements are unconstitutional.
So if the legislature had said 5 calendar days here, would you say it's unconstitutional?
Yes. And I would also say that the inference or the inferred language that the appellate would have this court read into the inpatient Baker Act proceeding would also create a conflict. What they want this court to do is to read into that 2000 or that 1971 statute, the inpatient Baker Act proceeding, language that says when counting the 5-day period, do not count Saturdays, do not count Sundays, do not count legal holidays. That's the interpretation they want you to adopt. I submit that's not a logical interpretation and basically flies in the face of the rule of statutory interpretation that you don't insert language into the existing statute when interpreting it. You interpret the statute pursuant to what it says on its face, the plain meaning. And even if we
Aren't they
did...
saying that you do count those days? That you count 5 calendar days is basically their argument. You do count them.
Well, maybe I stated that backwards. Yes, they're asking you to read into the statute that you do count weekends, Saturdays, Sundays, and holidays. But that language is not in the statute. The statute is silent on that language. They're asking you to infer that word and place those words in the statute, but I submit that's not the legislature's intent, and even if it was, we would create a conflict, a constitutional issue here.
Are you saying that the legislature could never enact a procedure that says, in a civil case, that when A happens, B has to happen within 5 calendar days?
They can create situations where, for example, in the Baker Act, a lot of things have to happen within fixed time frames.
As far as a court proceeding?
As far as a court proceeding?
Yeah, for instance, if the legislature said on temporary injunctions for protection that a judge has to enter an order within 48 hours after the pleading arrives to the court. That's less than 5. That's less than 5. That's less than 7 days under Rule 1.090. He's saying that the legislature would be without authority to do that.
I would submit, Your Honor, that is directly the legislature intervening in the practice and procedure of the courts, which the Florida Constitution has basically given that to the Florida Supreme Court. And I believe Article 2, Section 3 says that powers that are constitutionally bestowed upon the courts cannot be exercised by the legislature. So I think that would be a clear case of the legislature trying to control the practice and procedure of a court, which is prohibited. And there's a good bit of case law to the effect that those types of efforts by the legislature are unconstitutional, and where they reach in and try to control the practice and procedure of the court, they've been struck down. So in this case, I really don't think we ever get to the constitutional issue, because I think the logical interpretation of these two statutes when read together is that you're not supposed to, the legislature probably doesn't want you to count or wants you to count working days. And that's not inconsistent with the Florida Rule of Civil Procedure, because what does that mean? When they say working days, that means working days would exclude Saturdays, it would exclude Sundays, it would exclude legal holidays. So working days is not really inconsistent with Rule 1.190A. So there's not a constitutional conflict between the outpatient procedure and the Florida Rules of Civil Procedure. And I think if you were going to read anything into the inpatient procedure, you possibly could read into it that same working day criteria, which once again would not be in conflict with Rule 1.190A. I think probably the best way, the most logical interpretation, would be to look at these two statutes, conclude that working days is not inconsistent in the outpatient procedure with the Florida Rules of Civil Procedure 1.190A, and also conclude that the statute as written in 1971 for inpatient Baker Act proceedings doesn't have a time period for computing the days, so you continue, as you have historically, just continue to apply the Florida Rules of Civil Procedure, Rule 1.190A.
And how would you distinguish the Attorney General's opinion?
The Attorney General's opinion does not really deal with the issues. It makes no mention of Florida Rule of Civil Procedure 1.190A. It primarily looks at the statement in one section, I think it's section 394.468 of the Baker Act, and it says that those procedures that these hearing procedures and the operative procedures and the notices and all of these things are basically substantive law, and that they're not subject to the court rules. But they aim that basically at the Department of Children and Family Services, and they aim it at, in fact, it says when you read the statute, the sentence, it doesn't say for everything, it says the procedures of the department. So I first would say that the Attorney General is misreading that particular statute, reading it too broadly and applying it to the courts. Second, if the Attorney General opinion does actually believe that the legislature can, by merely declaring that something is substantive, make the final decision that something is substantive, and the courts have to abide by that, I would submit that he's misreading the law. The final arbiter of whether something is substantive and within the ambit of the legislature or procedural as it affects the courts and within the power and the authority of the Florida Supreme Court is a decision that the Florida Supreme Court makes, not the legislature. So for those reasons, I would say I disagree with the Attorney General's opinion. It is only an opinion. It can be deemed persuasive, but it's certainly not binding. Having been involved in securing several Attorney General's opinions and knowing how the process works, depending upon what person in the Attorney General's office was assigned to it, how important the Attorney General thought it was, there can be a whole lot of different levels of research and thought put into that Attorney General's opinion.
Well, this is unique to us to have a public defender tell us that we should rely on the Attorney General's opinion. So.
Well, I will, perhaps in another situation, I will be arguing in favor of Attorney General's opinion, but I hope I would do so on the basis of the good research and the thorough research that was in that Attorney General's opinion. And in this particular one, I think they just didn't deal with some of the issues, probably the most important issues.
Any questions? All right, thank you.
Okay, thank you. I guess I would just conclude by asking this court to enter an opinion which affirms the decision of the lower tribunal. Thank you.
Thank you.
All right, Ms. Radke, you have 2 minutes and 16 seconds.
Thank you, Your Honor. Just briefly, I would start by distinguishing the Massey case that the appellee is referring to. That case involves statutes which have to do with property rights. It's not a special statutory proceeding that's involved in that case, unlike the Baker Act case, the Baker Act. Also, Statute 394.468 is referring to admission and discharge proceedings not being subject to the court procedure rules. It further says that those matters within the purview of that part are deemed to be substantive and not procedural, which sort of, at least in the wording, takes it out of the rules of procedure and takes it out of appellee's concerns for separations of power. It is the appellant's position that the Baker Act hearing itself, where the court decides whether a person is discharged or continued in their admission, is part of the admission and discharge procedure, and that therefore the Attorney General position is correct. And I do recognize the irony of me arguing that, an Attorney General's position. But, and finally, I would say that the Baker Act itself is like the Rice Act, something that is a special statutory proceeding.
Let me go back to your reference to Rule 1.010. It
Yes.
says, "The form, content, procedure, and time for pleadings in all special statutory proceedings," arguably this is, "shall be as prescribed by the statutes governing the proceeding unless these rules specifically provide to the contrary." That seems to be saying that the rule would govern over the statute if there was a conflict. That the statute's provision on time and procedure would only govern if the court hadn't enacted a rule to deal with that.
To some degree, I can understand where the court is taking that reading or looking at it in that fashion, but to some degree that rule seems to read as something where it depends on where you place the emphasis, which word. It's not exactly a model of clarity.
It says procedure and time for pleading in all special statutory proceedings shall be as prescribed by the statutes governing the proceeding unless these rules specifically provide to the contrary.
I guess the question is whether that applies just to pleadings or whether, that would be one reading that could be taken on it.
All right, your time is up.
Thank you, sir.
Thank you.
Thank you.
We're being recessed.